This guide explains Texas seasonal farm worker wage rules under the H-2A program for 2026. We are using official sources from the U.S. Department of Labor at dole.gov, the H-2A wage page at flag.dol.gov, the seasonal jobs portal at seasonaljobs.dol.gov, and the electronic code of federal regulations at ecfar.gov. The focus is standard non-range agricultural work in Texas. If the job is herding or livestock work on the range, separate monthly H-2A wage rules may apply under Title 20, Code of Federal Regulations, Sections 655.210 and 655.211. In the next slides, we will walk through the Texas wage floor, the highest wage rule, piece rates, equal treatment for corresponding workers, overtime reality, guaranteed hours, and enforcement steps. Start with the Texas snapshot. On the official H-2A adverse effect wage rates page at flag2l.gov, the current Texas rate for non-range H-2A work is listed at $15.79 per hour. On the U.S. Department of Labor state minimum wage page at dole.gov, Texas is listed at $7.25 per hour, which matches the federal floor. That means many Texas H-2A jobs start far above the ordinary state minimum wage. But this is only the first checkpoint. The legal question is not, what is one wage number? The legal question is, which official wage number is the highest one that applies to this contract and this work? According to Title 20 of the Code of Federal Regulations, Section 655.120, the employer must offer, advertise, and pay at least the highest applicable wage. That section lists the main wage ladder. It includes the adverse effect wage rate, or AEWR, any approved prevailing wage, any agreed collective bargaining wage, the federal minimum wage, the state minimum wage, and any other higher wage rate the employer intends to pay. If the pay systems use different units, for example, hourly pay and piece rate pay, the job order still has to disclose the highest applicable rate for each unit that is being used. The same section also matters during the contract. If a higher updated AEWR or prevailing wage takes effect while the contract is still running, the employer may have to raise pay from that effective date. The Wage and Hour Division explains in Fact Sheet number 26F on dole.gov that H-2A employers may use piece rates when the method is properly disclosed in the job order. But the hourly minimum still controls the weekly result. If the worker's average hourly piece rate earnings fall below the required hourly wage for that work week, the employer must supplement the pay. The same fact sheet says wages must be paid free and clear, without unauthorized deductions or kickbacks to the employer. It also says H-2A workers must be paid at least twice a month, or more often if common practice in the area requires it. So even when the pay method looks complicated, the employer still has to make the paycheck reach the legal floor and pay it on time. Another core rule is corresponding employment. On the official U.S. Department of Labor H-2A materials at dole.gov, the agency explains that some U.S. workers doing the covered work can be protected by the same H-2A contract rules. Title 20, Code of Federal Regulations, Section 655.122 says the job offer must provide U.S. workers no less than the same benefits, wages, and working conditions offered to H-2A workers. That means an employer cannot promise one pay structure to the H-2A crew and then recruit U.S. workers on weaker wage terms for the same covered work. Experience premiums, piece rate details, and wage supplements still have to be disclosed honestly, because workers need the real contract terms before they accept the job. Now for a rule that surprises many workers. Long hours do not automatically mean overtime under federal agricultural law. In Fact Sheet number 12, on the official Wage and Hour Division website at dole.gov, the Department of Labor explains that employees employed in agriculture are generally exempt from the overtime pay provisions of the Fair Labor Standards Act. This is commonly described as the agricultural overtime exemption in Section 13, subsection B, paragraph 12 of the FLSA. Minimum wage and record-keeping rules still matter. And duties still matter too. The same fact sheet warns that some related work, such as certain packing or storage tasks involving products from another farm, may fall outside the FLSA definition of agriculture. The contract protects wages in other ways too. On the official H-2A overview page at dole.gov, The department says workers must be guaranteed employment for a total number of hours equal to at least 75% of the work period stated in the contract. Title 20, Code of Federal Regulations, Section 655.122, also covers transportation and subsistence costs. After the worker completes 50% of the contract, the employer generally must reimburse inbound transportation and daily subsistence if those costs were not already advanced. When the contract ends, return transportation and subsistence rules can apply as well. Housing, tools, and transportation between housing and the job site are also regulated because illegal cost shifting can eat into the worker's pay even when the hourly rate looks correct on paper. If the paycheck looks wrong, start building the record immediately. Save the job order, pay stubs, piece tickets, schedules, text messages, and any notes showing what rate was promised and what work was actually performed. The Wage and Hour Division of the U.S. Department of Labor at dole.gov handles H-2A and Fair Labor Standards Act complaints and publishes worker rights materials in multiple languages. The Seasonal Jobs portal at seasonaljobs.dol.gov is another official source for program information. And the Wage and Hour Division helpline listed on official fact sheets is 1-866-4-US-WAGE. This presentation is an educational guide, not legal advice, but knowing the official rules and acting quickly can make a major difference when wages are short.